in. There's some people coming in now, so we want to go ahead and get started, as I said. Welcome to our monthly webinar, which is H-1B Compliance Essentials, what employers and employees need to know about H-1B visas. Thank you so much for joining our webinar. Please be sure to stay on mute until we are able to get to the question and answer portion of this webinar. And in the meantime, we'll just move forward and let people in as they come in. Okay, so before we get started into the meat of the webinar, I do want to let everyone know who's on and those who are going to watch the recording that the information that we're providing in this presentation is general in nature. It should not be applied to your specific situation because every case is different. So what we're providing to you today is a starting point for you to kind of understand the basics of H-1B rules and compliance. And then, of course, if you have specific issues or concerns that you're experiencing regarding your own visa, then please do reach out to an immigration attorney so that they can give you specific advice related to your situation. Okay, as I mentioned, we will have time to answer questions during this webinar. So if you have questions along the way as you start to see some of the information being provided, go ahead and use the chat panel of the Zoom platform to just type and send your questions, and we'll definitely start there with any questions as we go along. We do ask that because this is a public forum, you do not want to have your own information in a public forum. We want to keep things confidential. Please try to ask your questions, if you have any, in a very general manner, not providing a lot of details about you personally. Okay. So why are we here today? Well, we're here to talk about H-1B visas, and H-1B visas are probably the most popularly used visas for those who are professional workers. So today we're not really going to talk much about how you qualify or whether or not you are able to get an H-1B visa or what the process is generally. What we're here to talk about is the fact that if you do have an H-1B visa, or once you get your H-1B visa, there are certain requirements that go beyond just receiving the visa. So for those on the employee side, there are requirements that you have to be sure that you comply. But sometimes even more so on the employer side, there are requirements that an employer has to follow. And in particular, for those who are H-1B employees, it's important for you to know what are the requirements for employers, because it can impact you as well if an employer is not complying or requiring you to do certain things that might not be within the parameters of your H-1B visa. So that's why it's important, whether you're an employee or an H-1B employee or an H-1B employer, that you know the specific requirements that the government imposes on both. So as I have on this slide, there is an enforcement and investigation part to the H-1B process. And we have actually several government agencies that are responsible for the compliance. So when we talk about that, we're going to talk about the different aspects of H-1B compliance and some of the agencies that are involved. So one of the agencies definitely would be USCIS, which is the agency that actually issues the visa. So that's where you apply to the USCIS, or which is part of the Department of Homeland Security. You apply for your H-1B visa with that agency. But they can also, after approval of an H-1B visa, they also have powers beyond that in terms of being able to visit the work location and see if you're compliant with the employer and the employee are compliant with the requirements of the H-1B visa. And of course, if they feel like there has been non-compliance or some issue that they find after approval, they can either deny it, or after applying, they can either deny it, or if they've already approved the petition, they can always revoke it as well. And then, of course, that means for both the employer and the employee, there's a loss of the H-1B visa. In addition to the USCIS, we also have the Department of Labor, which is very much part of the process for H-1B visas. And so the Department of Labor has its own requirements, and they can also reach out to employers after approval of an H-1B and audit the employer. And if they find the employer is not compliant, they can also fine or do worse, fine the employer or even remove them from the H-1B program. And then finally, is particularly, again, for employers and employers, there is what we call the WHD, which is the Wage and Hour Division, which is part of the Department of Labor. And what that Wage and Hour Division does as it relates to H-1B visas is that if there's a complaint, particularly from an employee or even the general public that reaches out to the WHD and says, hey, this employer is not compliant with the H-1B visa, in particular, for example, if they're not paying wages, that sort of thing, as we talk about later, then the WHD has the power to reach out to the employer and potentially fine or cause the employer to or impose penalties on the employer. Okay, so what happens when we talk about penalties? As I just mentioned, penalties usually go to the employer. It's not typically we don't see monetary penalties for an H-1B employee. So if an employer has not complied with the H-1B requirements, then they can be subject to monetary damages, money damages, and those damages could be paying the H-1B employee or even paying another employee that believes that they have been harmed by the H-1B employer in their administration of the H-1B program. There can be reimbursement of expenses, caused, for example, attorney's fees that are imposed because of the pursuit of a claim against the employer. There can be back wages if the employer has not paid according to the requirements of the H-1B. And there can be debarment, which basically means that the employer would be banned from using the H-1B visa or sponsoring an H-1B visa for any future employees. And then, of course, oftentimes, particularly in today's day and age, where immigration enforcement is considered to be, at the top of the priority for the government, at least in publicizing the efforts that it's making to control immigration, there can be negative publicity. So there can be, of course, announcements to the public about a particular employer's infringement or violation of H-1B rules and what has happened to that employer. So those are really very serious things that can happen when there is when the government determines that there's not been compliance or there's been non-compliance with H-1B employees' employment. Sorry, I'm just checking on some things. So now let's go specifically into the types of requirements or types of rules that employees and employers should know about. There's no time to cover all of the things that are all of the rules that are imposed, but I want to cover the things that we see the most issues with. And so what we'll talk about initially is to start talking about the H-1B application process itself, just so there's a basic understanding of what is required or what are the steps through the process. So if an employer applies for an H-1B petition, or submits an H-1B petition for a H-1B worker, then let me just hide this panel, I'm sorry. Then basically, they have to do a few things, quite a few things actually, but one of the key things that they must do is to apply to the Department of Labor for a labor condition application, and that form number is ETA 9035. So this is an electronic application that goes to the Department of Labor, basically saying, we, the employer, is applying for an H-1B position, and this is our proposed pay rate, and we're going to pay the required rate to that H-1B employee. So there's a lot of different aspects to this application, but that's basically what it's saying, that we as an employer are going to treat this H-1B employee the same as any other employee and provide the same wage, or at least meet the minimum required wage, as well as providing any normal benefits that we usually provide to employees. So that part has to be applied for and approved by the Department of Labor before the employer can actually apply to the Department of Homeland Security, USCIS, and submit what's called the I-129 petition. And in that petition, there's a lot of information about the employer as well as about the proposed H-1B employee. So this has to be also submitted to the Department of the USCIS. And just to be clear, this I-129 petition applies for a new H-1B as well as for any extensions or renewals. So the H-1B or if you're changing employment, it's the same process. There's really not much of a difference in terms of process for someone who's a new H-1B worker or someone who's changing employers or someone who's just extending their current employment. The process is pretty much the same. There's just different boxes to check off on the application form itself. So once the USCIS has reviewed the application, and if all is well, they approve it, then of course there is an approval notice that is issued that says that for a certain period of time, usually 3 years, sometimes less than that. It just depends on the circumstances. But for that certain period of time called the validity period, that H-1B worker can now work for that employer in the capacity that was stated in the H-1B application. So it's very critical that the employer understands their H-1B application and understands the job and understands what the employee can and cannot do with respect to that job based on the H-1B petition, because the government will always go back to the LCA and the I-129 to determine whether there is compliance. So it's important for both parties, employer and employee, to know what is in that petition and to comply with it. So I basically want to just cover a little bit about what needs to go into the petition or some compliance issues that might come up. And so you want to be sure that the petition, I-129, as well as the LCA, sorry, has the accurate information, because again, that is the petition and the LCA are going to be referred to whenever there is any kind of compliance audit or concerns. So if you are the employer, you want to be sure that you are using the correct corporate name. Oftentimes we will see employers that maybe use a trade name, or they have various different entities that they use. And sometimes what they give us is not the correct one, not the one that's actually going to employ the individual employee. So it's really important that the employer provides the correct company name and the correct employer identification number for the company that is actually going to pay the H-1B employee. So if the employer has several different companies, and maybe the employee might be providing services to all, but the actual paying entity is going to be different. So you want to be sure that the actual sponsor is the employer, that is the employer entity that is actually going to issue the paycheck. The other very important part is the actual employment situation. As I mentioned, the H-1B petition, you include a lot of information about the job itself. So you want to be sure that you have a very detailed job description of all the duties, or as many duties as you're aware of for the position, not only to qualify for the H-1B, but also to know that this is the limits of the job itself. You cannot say, I'm going to have someone working on accounting, and then all of a sudden during that H-1B trend, when they get the H-1B, you now put them into a totally different position, or a position that may not be as related to that one. So you have to be sure that you have the right job description and consider all the information, all the duties that employee will be engaged in. And then, of course, really important is all the work locations. Some employers have multiple locations where the employee will be working. They may work at a client site. They may work long-term. They may work at home. It might be a remote position. They may not work in the office, or they may work in the office sometimes. So If there are multiple work locations, then you definitely want to be sure that you identify all the work locations in the application. Because as we'll see later, if those things change, you do have to update the application. And then finally, the business itself. And what I mean by the business is that, especially for smaller organizations, the USCIS, when they get an H-1B petition, will want to be sure that that the employer is an actual existing business, and that they actually will have, or it seems that they are operational. And so what you want to be sure of, especially if you're a newer business, is that you are registered for what's called the VIBE program, which is a verification program that the government uses for small businesses. And there's a website here where it's a free service, but basically any small business can go to that website and fill out their information. And that is a resource that the government uses to determine whether or not they feel comfortable that the organization actually exists. In addition, if you're an employee or an employer that has more than one H-1B employee, then you want to be sure that you track and identify those, because if the USCIS sees that there's a lot of applications that are coming in from a particular employer, especially a small one, then they may be looking at that and saying, is this employer actually what they call an H-1B heavy employer, like you have more than half of your employees are H-1B. There are some differences there for an employer that has a lot of or a relatively high number of H-1B employees, and those who have a few. There are some compliance requirements there. So it's really important to track the number of H-1B employees that you have and make sure that you're not an H-1B, or if you are, an H-1B dependent employer. Okay. So let's go on to some critical timelines and deadlines that employers and employees need to know. And there are quite a few. Again, I do not have time to go through all of these, but I wanted to cover those that are particularly important. So if you already have an H-1B, as I mentioned, there is a validity period. So there's a certain period of time that you are considered to be in valid H-1B status. So if you are going to continue to be at H-1B status and want to remain working for an employer, or the employer wants the H-1B employee to continue working, then it's important that the employer submit the renewal petition on time before the H-1B expires. So that's very important to do. And because there is time required in order to prepare an H-1B petition, it's not something you can do in a day, the day before it expires. So you want to map that out, and employers should be tracking it, as well as employees need to be tracking their expiration dates so that they reach out to each other to be sure that the process is started in a timely manner. One of the things that's important, usually you are not able to apply any earlier than 6 months before the expiration. So it's not something that you don't start a year ahead of expiration, but within 6 months of expiration, you want to look at extending and working on the extension of your H-1B approval. And for sometimes it's important for other reasons, in particular, as some employees' driver's license or professional licenses, travel plans, other reasons that an H-1B approval is needed very quickly. So in that case, applying early enough sometimes will get you that approval on time, but sometimes you will have to request premium processing because that's the only way you're going to be guaranteed that you're going to get that approval on time. Now, keep in mind, though, that aside from those other reasons for needing approval, if you are concerned with continued work authorization, then you do not have to have an approval to continue working. And so what I mean by that is that if you are applying for an extension of your employment with the same employer, or if the employer is applying for the H-1B employees extension of their H-1B visa, as long as the H-1B petition is filed, then there's an automatic extension of the H-1B work authorization for up to 240 days, which is about 8 months. So if you file, if your H-1B is expiring on June 30th and you file on June 26th today, you will still be able to continue working past June 30th because of the fact that you have applied and there's an automatic 8-month extension. So that will allow you to continue working. But of course, if you need to have a faster approval for the purpose of a driver's license or some other issue, then you would want to not wait till that timeline for the renewal. So next, I also wanted to talk about material changes. And I think this is really important because sometimes we do see that employers and employees have made changes in employment and have not updated or amended the H-1B petition. And that can be an issue of compliance, and it could endanger the employee's H-1B visa itself. It can cause it to be revoked. So it's very important to understand that, again, the H-1B visa is very specific to the job, to the location, to a lot of different factors. So if there's going to be a material change to the employment situation, so for example, there's going to be a change of place of employment, a long-term change, that can be a reason for amending, which basically means submitting a new H-1B petition to explain and get approval from the government that we're making this change in place of employment. Or if there's a change of duties that are very significant, that maybe that would put you in a different classification, particularly with respect to wages, then you might need to file the employer might need to file an H-1B petition. Or there can be a change and we've seen this in a number of work hours. So for example, someone's full-time and they want to go part-time. Well, if you're on a full-time H-1B, you can't just say, I'm going to go part-time without first getting or filing a request for approval, which is an amended petition to the USCIS. And even going from part-time to full-time, if it's not contemplated in your initial H-1B petition, then you're going to have the same issue. You're going to need to get the amendment done. So basically, I'm referring here on this slide to the actual rule, what's called the Code of Federal Regulations rule by the government that says an amended petition is required if these types of material changes are going to take place. And it's not after the fact. The employer, meaning the employer, must file the amended petition before those changes occur. So if your employer says, hey, we want to take you part-time because for whatever reason, it doesn't necessarily have to have a reason for it, but let's say we want to take you part-time, then the employer needs to file an amended petition before you start working part-time. So it's not something they can say the next day, I want to take you part-time. They're going to have to make sure to take at least a couple of weeks or so to get the application in process and file it. And once it's filed, even though it hasn't yet been approved, then you can move to part-time status, as an example. So any of those material changes where there's going to be a need for an amended petition, it's very important to get that done before any of those changes occur. And so if there is, on the employer side or the employee side, if there is any talk of those kinds of things, whether it's promotion or change in duties, those types of things, it's really important to reach out to the attorneys to get the advice of whether or not an amendment is needed before those changes take place. Now, another time issue that's really important that we sometimes see come up as an issue and that employers or employees may not understand is when are wages due. So this usually occurs when someone gets an H-1B visa. So for example, if this is if you just received an H-1B visa, maybe you change from student status to H-1B status, and your validity period says October 1st, 2025 as the starting date for your H-1B. But the employer says, well, we really, we have to do a lot of different things before you can really start working. So we might not be able to get you on board until December 1st, right? Which is 3 months after the validity period starts. Well, the rule says the Department of Labor says that that is not allowed. So for example, if your H-1B starts October 1st, 2025, and you are in the United States because you're here as a student and you've changed to H-1B on October 1st, the employer must start you on payroll within 60 days of October 1st. So the latest they could not put you on payroll, not have you start work, would be 60 days. So that's 2 months. Well, actually, it would be December 1st in that case. However, but it wouldn't be December 30th, right? So it'd have to be by December 1st that you could actually start, or would have to have started your work and be paid. And there's really not many excuses, valid excuses that the government can give about that. They can't, I mean, not the government, the employer can give. They can't say, oh, well, we have to, find out, get some things done with our contract with a client, or in this case reference here where we have this Gabrielle Worth versus University of Miami. University of Miami said, well, we don't have hospital privileges, we don't have certain things in place, and therefore we can't put you on payroll until those things are done. And the government said, no, 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 it doesn't matter. If you don't have those things in place, and even if the doctor cannot, or that H-1B employee in this case cannot actually start performing services, they still have to be paid. They still have to be paid while they're waiting for you to complete your whatever you're doing to get them ready to start working. So that is the case if someone is already in the U.S. But let's say someone is outside the U.S., they get their H-1B visa stamped for the first time, they come into the U.S. On today, June 26th, 2025. They present themselves to the employer must put them on payroll within 30 days from the entry of that employee. So again, employers and employees need to know that there's not any extended time that you can just start working within that validity period. There are deadlines for that. There's also there's also requirements related to wages being paid in circumstances where there may not be productivity by the employee. So what I mean by that is that let's say, for economic reasons, the employer says, hey, I don't really have any work for you, so I'm just, you're not going to get paid because we have no work, like we have no client contract. So basically, we're going to have to put you on hold until we get a contract for you to actually be working on. And so that typically can happen, or not typically, but it can happen in certain industries, for example, in IT, maybe in some medical fields, depending on the situation. But in any event, if the H-1B employee is in that situation, it is not allowed for the employer to say that we are not going to pay you because we don't have work. So that's what's called benching, and that is strictly prohibited. We've also seen circumstances where, and I think we're going to see some of that because I've had some people reach out to me about companies saying, well, again, we are going to furlough all of our employees, meaning that we're not going to terminate employment, but we're going to put you on hold. You no longer need to come to work, but of course, we're not going to pay you as well. And that might be fine if you're a U.S. citizen. If you're agreeing to that, there's no, as far as I know, no issue related to that. At least not with immigration. But if you are an H-1B employee, the employer cannot furlough you. They have to, if they want to keep you as an employee, they're going to have to pay you regardless of whether or not they have any work or capability. Some other kinds of situations where we see non-productive time, and employers will say that we're not going to pay for that, would be things like, as I mentioned earlier, if you're a licensed professional, you have your H-1B approval, you were able to get the H-1B approval, but your license hasn't come through yet. Well, even if your license hasn't come through, if your timeline for starting work comes up, for example, 60 days from the time your H-1B was approved, or for starting of the validity period, then they're still going to have to pay you regardless of whether you have your licensing. Or if you're studying for licensing, or they're telling you, oh, you just go and study for licensing, and it's part of their requirement for you to study for licensing as part of your job, even though you're not producing any kind of uh, pay. Well, even though you are not providing services for your employer, that still needs to be paid if it's part of the job requirement. And then finally, if there's any training that's required, then I'm sorry, the employer must also pay that as well. So you can see there's a lot of requirements here where typically it might be fine for someone, an employee who's a US citizen or has a green card and is not an H-1B worker. But in the case of an H-1B worker, there are a lot of restrictions in terms of what the employer can do as far as not paying wages. And then the last thing to talk about this with respect to wages is termination of employment. So if an employer can terminate employment, follow any rules that are, employment rules that are required in most cases. For example, in the state of Texas, we have what's called employment at will, which means, usually an employer can terminate an employee for any valid reason. Or no reason. They don't necessarily have to give a reason in many instances. So even though an employer has applied for and received a 3-year H-1B, that does not mean that the employer cannot at any time during that 3-year period terminate employment. But if they do terminate employment, they have to be very clear on the fact that they are terminating, and they have to take certain steps in order to show that they are terminating. And these are the 3 steps that are required. The employer must give a written notice to the H-1B employee that they're terminating employment. They must also offer to the employee the airfare or transportation to leave the US. You don't have H-1B employee does not have to accept that, but definitely the employer has to offer that. Now, if the H-1B employer accepts it, that means they're accepting a ticket. It doesn't mean that the employer has to give you cash to buy a ticket. The employer can buy a ticket and give that to you to confirm that they're giving you return transportation from the US. And then the last thing that the employer must do is to provide a written notice to the USCIS withdrawing the H-1B. So if the employer does not do these things, then the termination of employment as it relates to H-1B is not effective. So what does that mean? What that means, it doesn't mean that they have to keep you on board in terms of working, but what it does mean is that if they delay, like let's say if they do not do all of these things, then the H-1B employee actually can have a claim through the Department of Labor for wages to be paid until this effective termination takes place. There was a case of many years ago where an employer basically did not take these steps. The H-1B employee sued or made a claim through the Department of Labor, and basically got over a year's wages paid, even though they were not working. They got back wages because that termination did not take place effectively. So it's really important for the employer in particular to make sure that they effectively terminate. Now, if they don't effectively terminate for the employee, it doesn't really affect you as far as being able to find another position and be able to get a new employee's H-1B sponsor. And those kinds of things. But for the employer, this lack of effective termination does have significant consequences. Next, we'll talk about the labor condition application rules, as I discussed before. And this, again, relates to wages. So the labor condition application rule is really, really focused, or the main reason for it is to ensure that employers are paying the H-1B employee the same or even sometimes higher, so the same as they would any US employee. So they're avoiding the potential for an employer to hire an H-1B employee because they think they can pay less. Okay, even though we hear a lot in the public discourse that H-1B employees are undercutting US employees. Well, by the rules, they're not supposed to do that. The rules say that employers must pay the higher of the actual or prevailing wage rate, and we'll talk about what that actual prevailing wage rate means. They must also, as I mentioned before, pay for non-productive time. So actually, it's even more favorable for H-1B employee that they're actually paid even if there's non-productive time, whereas a U.S. citizen might not necessarily have that recourse. And then employers must offer the same benefits if they have healthcare, any other kind of insurance, 401k, all those things must be offered on the same basis as they are to other workers. So how do we look at what are the sources of the prevailing wage? So typically when the H-1B application is being prepared, as I mentioned before, you have to file a labor condition application as part of that process. And in the labor condition application, you have to specify what is the wage source that you're using or the employer has to specify what is the wage source that we're using to prove that we are indeed paying the going rate for that position. And so we're going to look at the prevailing wage sources, and the most often used source is the Occupational Employment Statistics OES survey. This is a Department of Labor survey where they annually conduct surveys to see what is the rates being paid for physicians, doctors, any occupation you can think of in the local area. For example, in Dallas, where we are, Dallas County, what is the going rate for a internal medicine physician? So they're going to look at that, and then the employer in preparing the LCA will look at this as well and determine, okay, if the going rate is $200,000, I'm paying 210. I'm definitely above the prevailing wage, so I'm meeting the prevailing wage. So that is the usual process. There are other wage sources that some people will use. There's the U.S. Department of Labor prevailing wage determination. This is the safest wage source to use, but it takes too long to get that determination. It actually means that the employer has to file a request to the Department of Labor, and that may take 6 months or more. Doesn't make any sense for an H-1B petition. They need to move a lot faster than that. So usually most attorneys will turn to the Occupational Employment Statistics and recommend that to the employer. But there are these other types of very specific types of surveys that in most cases you won't need to use. However, there is sometimes if the employer says, I just cannot go by the OES because that's way too high. My other employees aren't even being paid close to that amount. If the employer can come up with an independent survey that meets the DOL criteria and proves that the wage that's being offered does meet that survey result, then it's possible to also get the H-1B approved through that independent survey as opposed to the OES. But it's important to keep in mind that there's different levels even for the OES. So this is a typical example of an OES wage survey where we're looking at, I believe this is like a computer related occupation and in the Dallas County area. And so definitely, it's for 2024. You want to pull up the most recent one. And then as you look at, if you've pulled up the right occupation, you can see there's different levels, and level one starting with a new person, somebody right out of school. And then we look at different levels of experience. So not only are we looking at, just what is the occupation, but what are the requirements for that position? Do you require 10 years of experience? Well, if you require 10 years of experience as the employer, then you're probably going to be at level 3 or even level 4. So you can't say, oh, $57,000 for someone with 10 years of experience. That's not going to work. You're going to have to move that wage level up. But those are the things that are considered when you are looking at the prevailing wage requirement. And so I'm going to move a little quicker because I know we have a lot more to cover, but there's also the actual wage. So as I mentioned, the employer has to pay the higher of the prevailing wage or the actual wage. So let's say the prevailing wage is $100,000, but for that same job, at the employer's company, they're paying $110,000. Well, that means that the H-1B employee has to be paid $110,000, not even though the prevailing wage is less. Because again, the employer is not to treat an H-1B employee lesser than they would a US citizen or someone with a green card. So these are the factors that the government looks at and says, if they come to audit in particular, okay, show us that, all your other employees with the same qualifications and experience, what are they getting paid? Is this H-1B employee getting paid the same thing, the actual wage itself? And another question we get quite a bit is related to the employer's obligations for paying fees related to the H-1B. And so this is really a Department of Labor rule where the Department of Labor says that H-1B fees or fees related to applying for an H-1B should be considered a business expense of the employer. So most expenses should not be recovered from the H-1B employee's wages, or they should not be reimbursed or paid by the employee. So these are the typical fees. We have the ACWIA fee, the anti-fraud fee, there's an asylum fee. There's a lot of fees associated with an H-1B application, and generally, and the attorney fee. So the government really, the Department of Labor says that those fees should be paid by the employer. And even the attorney fee in most cases should be paid by the employer. In particular, if the attorney fee is $3,000 and the salary is $100,000, and so if you're deducting that $3,000 from that salary or reimburse and getting reimbursement for $3,000 from the employee, that is considered a reduction in salary, and that is prohibited there if it's going to drop it below the prevailing or actual wage. In most cases, it will. So we always let employers know best case, just to avoid any issue, is to pay all the fees associated with it. It's also important to know that employers cannot require repayment of any cost. So for example, if an employee terminates employment, or even if the employer terminates employment, they are not to require the employee to pay back the costs that they incurred as part of the H-1B process as well. Okay, so now we're going to talk about record keeping rules, because this is really important for many reasons, but one of them is that it is required. So in particular, as we talked about with the LCA and the Department of Labor, they require that there's certain records that the employer must keep on file ready for public access, meaning anyone who comes off the street and says, hey, I want to see your public access file related to this H-1B. It has to be available for them. And then it also needs to be another file available internally for the Department of Labor if there's ever an audit. Then there's also what we call the FDNS, which is a Fraud Detection and National Security Unit of the Department of Homeland Security, which has the authority to go on to employment sites and conduct audits, oftentimes without notice. So what we call surprise site visits. So it's important to know that you need to keep those records in case any of these audits happen either through the Department of Labor or the Department of Homeland Security. So one of the examples, let me close this up here. One of the, or just briefly about the public access file, we have various information that needs to be kept. And usually this is information that is gathered and created at the time of the LCA filing and the H-1B petition filing. So you can see there's a lot of information. The LCA needs to be in the public access file, information about what the rate of pay is. There's a memorandum that describes what is the actual wage and how that was determined, a copy of the prevailing wage survey, and proof of a posting. There is a posting requirement by the employer, or for the employer, to post the LCA or a notice of the LCA on its facilities. Other things that need to be kept in there is acknowledgement of receipt. So as an H-1B employee, you are entitled to see the LCA itself and receive a copy of that. So you would acknowledge that. Summary of the benefits offered to all workers. So again, showing that we offered these benefits and it's offered to the H-1B employee as well. And then if an employer has a lot of different companies. They may need to list all the different companies that it's a part of because if they're affiliated with each other. So, again, some companies have a lot of different entities that they use to operate or do business, but they're all associated and affiliated with each other. So they would be considered a single employer, even though they have different companies. And so they have to include that information into the public access file. Importantly, if there are changes, as we talked about earlier, if there's going to be a need for amendment of the H-1B because there's really changes in employment, situation, locations, all those things, the public access file needs to be updated, needs to include a new LCA if it's required, any changes in pay that are substantial, salary adjustments, things like that, all need to be kept in the public access file. If a company merges or sells, if a company is merging into another company or they're selling the company to someone else who's taking over the H-1B employment, then there are other documents that also need to be included in the public access file, such as a notarized statement, a list of workers. I mean, it's just a lot of information that needs to be gathered and included in that public access file so that it's understood that there's a new company taking over this employment situation, particularly for H-1B workers. Now, how long does this information need to be kept? The public access file needs to be kept by the employer, either at their principal place of business, or they can keep it at wherever the employee is working. Most companies will keep it at their principal place of business to keep it centralized. And it must be kept as long as the H-1B employee is employed with that company and at least 1 year after termination of employment. So there's also a labor condition application that needs to be kept on file as well. So this one is not disclosed to the public, but it's really just kind of mirrors the public access file, but it's something that is kept in place so that if the Department of Labor asks for this information, it's an easy access for them to, or an easy way for the employer to access and give them that information. So lastly, I want to quickly go over, so I want to leave a few minutes, of course, for questions, is how to prepare for an audit. Because as I mentioned before, there can be site visits, there can be audits. So Department of Labor generally usually gives a written notice of audit that they decide either on their own randomly, or someone might have reported or made a claim against an employer related to H-1B. The Department of Labor may decide to audit the employer to be sure that they've followed through with all the requirements. Then you also have, as I mentioned, the FDNS of the Department of the U.S. Immigration Services. They can also audit and actually oftentimes will do what's called a site visit, that they'll come on to the proposed work site and ask questions and seek information. So employers and employees need to be aware of this possibility and also be prepared for it. So to prepare for an audit or a site visit, employees should thoroughly review the H-1B petition, make sure they understand it fully, make sure it's correct. If there needs to be made amendments and change and things done because there's been changes, look at that. Conduct an audit yourself and see, do we have all of these things that we might be asked for if a government agent comes to us. And if you have an employee, or if you're an employee that works at a client site, then the client needs to be aware that there's a potential for a site visit. If all of a sudden an auditor comes, or a fraud detection inspector comes and starts asking about the H-1B employment there, the client needs to be aware of that and needs to understand that this is something that could happen. You need to be sure you identify the people who will be able to communicate with the auditors, because of course, the receptionist isn't the person to be answering questions about that, but they should know if we receive an audit or receive a site visit, refer them to HR manager, whatever their name is. So you want to, again, establish those types of procedures and training so that everyone understands what to do if an audit takes place. You also make sure, again, to prepare a file, probably in HR or whoever's responsible for employment issues, to be sure that they have these types of information in that file ready to go when asked for, because oftentimes they may ask to see it immediately, or they may give time to do it, but it's much better to be able to have those things ready to go without having to scurry around trying to find the information. there. All right, so that brings us to the end. We have about 10 minutes for questions, and I did notice that we did have some questions, so I want to make sure we address them. Thank you for providing them in the chat. I know there was some answers given, but I want to just make sure we're elaborating on those. So is the renewal petition required after 3 years on H-1B, or is this a restamping? So as my associate attorney, a senior associate Celsa mentioned, a renewal extension petition is required to extend your H-1B status. So what that means is that, as I mentioned, you have to submit the actual new LCA, new petition. Once that is filed, depending on where you are, it can be, well, usually if you're doing a renewal, you're already still in the US, you're working. So as long as that petition is filed, then you're in the US, your H-1B will be extended through that petition. But of course, if you are planning to travel or you need to travel outside the US, you will still need to go to the embassy and get the restamping to get your visa stamp extended for another 3 years or whatever time frame that is. And that will allow you to come back into the US. But always for H-1B extensions, a petition is required first through the Department of Homeland Security. And then if you need to get a visa stamp to travel, you would go to the embassy for that. Does the 8 months extension also apply when an employee does a change of employer, either to a new company or self-employed on the time, self-owned company on the time before their visa with the old employers expires? So generally, no, the 8-month extension is really for an extension with the same employer. However, if you are doing a change of employer, what happens is that when the new H-1B petition for change of employer is filed, if you have maintained your H-1B status or if you're within the 60-day grace period allowed for in some instances, then you can start work. You're authorized to start work with the new proposed employer, and you are able to continue working with them until a decision is made on the application, and that could extend beyond 8 months. So for example, if you file a change of employer, you start working with a new employer, and you're not using premium processing, obviously, but if you're not using premium processing, if it takes the government a year to decide that H-1B change of employer, you are still authorized to have been working with that employer for that year time frame. So it's a little different. It's actually, you can potentially have more time, more than 240 days if you're doing a change of employer. Okay. Let's see if there's lots of questions here. Okay. Another question is, if an employee does not receive termination notice from an employee and yet did change of employer and get denied. I think the question is, if an employee does not receive termination notice from an employee and did change of employer and get denied, can the employee continue to work with the employer? So I'm assuming you're saying that you just go back to work with the employer. That is possible as long as the employer did not notify the USCIS to withdraw their H-1B petition. And there's some other considerations there. So that's really on a case-by-case basis, but it is possible to happen. To renew H-1B after my initial 6 years, I need to have perm processed by the 5th year is a grace period there. So to renew H-1B, yes, I mean, there is what's called AC-21, which does allow some extensions. Your perm, as Celsa's mentioned, must be pending for at least 365 days. So really, it's not started by the 5th year, it's filed by the 5th year. So because a perm process can take a year just to get through before filing. So if you are going to try to get that, or if you want to be as safe as possible, you'd really want to start the process much earlier. You would probably want to start on in the 4th year and make sure that the perm process with the Department of Labor is filed by the end of your 5th year. And by the end of the 5th year, then, you will have a year, and then you can have, at that point, if your perm process is still pending, you haven't gotten to the I-140 stage, then you can get a 1-year extension. But otherwise, you could run out of time if you're waiting. Well, you said started by the 5th year, so that's correct. I mean, started. Honestly, I would say earlier than that, just to really be safe on that. So you want to be sure you start earlier than that. If you started, and in fact, if you started earlier and you received an I-140 approval, which is the second step after the perm, then you're going to get a 3-year extension. So you can really save a lot of time and money if you are able to start earlier than that. So just so people can hear in the chat, can I travel internationally after starting the process? And yes, the perm does let you, the perm process in itself does not stop you from traveling. It doesn't affect your status at all. It's only at the last stage, which is the I-485 adjustment of status process, where you need to be sure that either you have an H-1B that allows you to travel, or you've applied for and received an advanced parole document as part of the adjustment of status process before you travel in itself. So there's just a few people here that have asked questions. If anybody who hasn't had a chance to ask questions, feel free to do so. We still have about 5 minutes there. So let me do this. Let me stop sharing, and I will go on screen and see if there's any other questions. And you can come off mute if you want.
Oh, great.
Okay.
Yeah, thanks, Anne. This is really good. So one more question, in addition to what I've said earlier, it's so the question I asked was, can an employee do a change of employer without the employer noticing USCIS, and if he gets denied, can he continue to work? So that's yes. Then can they travel while the application is pending for the change of employer? That's just what I want to ask.
Travel internationally, I would not do that.
Internationally.
Yeah, I wouldn't do that. Potentially you could do that if you'd have a receipt, if your H-1B visa stamp is still unexpired, potentially, but there's a lot of risk there at the CBP. So I would not, unless you had an actual H-1B approval from the new employer, I would not travel internationally.
Okay, what if it is the current employer? Can you travel if you have filed an extension with the current employer?
Oh, yes, you can, but you have to be mindful of the timeline again, because you have that expiration on your H-1B employment. So you need to come back before that H-1B expires on your visa stamp and your passport. So you have to be careful with that.
So you don't.
If you have, like, for example, if your visa expires in your passport on September 30th, right? And you have a pending extension, and you want to be sure that you come back before September 30th, unless, you still have to be sure you come back before September 30th, even if you have the
So the 240
extension.
days does not, the
It does not
240 days
apply for your
does not
travel.
apply.
No.
Okay.
No. Yeah, it only extends your work authorization. It doesn't extend your ability to do anything else on there. Yeah.
Okay, thank you.
I think there's a question here from Nilan. If I get laid off, starting my perm process in the 4th year, does that affect the chance of filing my perm process with a new employer? Well, to answer that question, no. You can always file a perm process with a new employer. You just need to be sure, mindful of your H-1B status, making sure that you file the H-1B transfer or change of employer in a timely manner as well. And if I enter the 5th year when I switch employers. So, again, you're going to be losing time again because you're starting later and you're switching employers. So there's specific issues with that. So having switching employment in the middle of perm or getting laid off, it can impact your ability for your extension past the 6 years. So that can be an issue. Okay, we do have a question. Do we help with EB1 applications? We do. Thank you so much. Yeah. Any other questions? Oh, and just to clarify, there's in the chat, Celsa said the perm does not transfer to a new employer. So you always, any perm process does not transfer, whether it's completed or not, it does not transfer to a new employer in most cases. So you will have to, a new employer would have to start that perm process over again. However, if you have gotten to the stage of, let's say, at least an I-140 approval after the perm, so you've gotten to the stage of an approval at the I-140 stage, then your priority date is locked in, and any new perm application can you still use the older first perm's priority date. So that's an advantage there. Okay, well, we are at the end of our presentation. Thank you all so much for joining us today. We hope this has been informative. And so please keep looking out for our next webinar. And if you have any questions or concerns specifically, please feel free to reach out to us and schedule a consultation with any of our attorneys. Thank you so much and have a great day.